On behalf of the Colombo Law Society, I welcome you to the third e-lecture organized by the seminar subcommittee of the Colombo Law Society. I'm Vijaya Gamage. I'm the president of the Colombo Law Society. We at Colombo Law Society are committed to make a strong and an independent bar. Our 4,000 strong membership is well spread into both the unofficial bar, official bar, then the private sector, as well as the state institution. This is the third e-lecture organized by us. The first two e-lectures have been very successful. The participation has been very encouraging. Our seminar subcommittee, in designing this e-lecture series, decided to have a single speaker rather than a panel of speakers, so the speaker can go into the subject matter deeply and thoroughly. Today's e-lecture also is going to be delivered by a very senior and a very respected practitioner on a topic of very practical relevance. I would like to thank the organizers of this event, the seminar subcommittee co-chairs, Mr. Chathura Galhena and Mr. Sanath Karunaratne, our treasurer, Mr. Nalin, Samarakoon, and the organizer, Mr. Imaz Imthiyaz. I especially thank Mr. Chathura Galhena for initiating this e-lecture series and moderating e-lectures as well. I would also like to thank Mr. Imaz Imthiyaz for taking trouble over all the technical issues. Colombo Law Society will be organizing e-lectures on every Friday evening at 5 p.m. Next week also we are going to have another e-lecture. I invite you all to join with us next Friday as well. Now, I invite our moderator, Mr. Chathura Galhena, to introduce the speaker and to proceed with the lecture. Thank you.
Thank you, Mr. President. Today I am technically handicapped since I don't have the facility of video, but anyway, I'm joining with audio facility. And my task today is to introduce the speaker. Mr. Rohan Sahabandu, President's Counsel, is a very well-known legal personality who is having a practice of over 45 years, who will be completing 50 years in another couple of years. And his main areas of practice is civil appellate jurisdiction. He's a practitioner who's seen in all courts of civil appellate courts, including civil appellate high courts, Court of Appeal, and the Supreme Court. And he is the editor, one of the editors of the Sri Lanka Law Reports for last 20 years, and is a person who has been involved in many activities in promoting and educating the young attorneys. Mr. Sahabandu was appointed President's Counsel in the year 2012, recognizing his contribution to the profession. Mr. Sahabandu was the Deputy President of the Bar Association in the years 2009 and 2012. In 2014, he was appointed as the Chairman of the Legal Aid Commission, which position he holds to date. And it's a pleasure to invite Mr. Sahabandu for today's lecture, and he's the best person whom we think to discuss today's issue, that is the areas affected or the impact of COVID-19, or rather the period of lockdown for the appellate procedure, especially the areas involving time bar and statutory time bars. So Mr. Sahabandu will discuss most of the aspects which he thinks that are important. And I invite all the participants to post your questions, which will be attended by Mr. Sahabandu at the end of the lecture. And without taking much time, I will invite Mr. Sahabandu to start his lecture. It is over to you, sir.
So, thank you. Thank you, Mr. President Vijay, for inviting me. You know that I became a member of your society long years ago. I would say about 30 years ago, I was a committee member of your society, and I still sort of get involved in all activities. I'm also thankful to my friend on my right, who you can't see, that is Chathura. And I was just telling him that he's assisting me in this computer thing, which I am not very knowledgeable. That long before he joined the bar, I was in practice. Now he asked me, and the society also asked me to talk about the appellate procedure. Now, appellate procedure, of course, is laid down in the rules set out by the Supreme Court, and also most of the acts that we come across, they give procedure and also give the fact that they can appeal to a higher court. So that is laid down in the acts. And you must also understand that all contested matters ultimately end up in the Supreme Court this way or that way. So that is the last bastion, and I'm extremely happy that I have been in that place for quite a long time, and I know what is happening. I might not know the law, but I know what is happening in that institution and about the procedures. Now, coming to the Supreme Court, recently the Supreme Court issued 2 gazettes. Now, we must be aware of the 2 gazettes. Why they introduced the 2 gazettes was that initially we had a gazette whereby the Supreme Court in 1991 said all special leave to appeal applications to the Supreme Court should be made within 42 days. That is Rule 7 of the rules. For those rules, I think you are very well, very aware of. And that was the rule 665/32 of June 7th, 1991. So that came in 1991, and according to that, rule number 7 says all special leave to appeal applications to the Supreme Court will have to be made within 42 days. Now, harping on that, you know that we had a problematic period, the pandemic, and then there was this lockdown. Then some places worked from office, some didn't work, and all that happened. And during the certain period, nothing took place. The Supreme Court thought it fit to consider that and issue another gazette. That was issued on the 6th of May 2020. And what the gazette did was, they were looking at Rule 7, and they said that in considering Rule 7, that's a 42-day period, the dates March 16, 2020, ending May 18, 2020, that's about 63 days, shall not be taken into account. So we have that Nonagate period of about 63 days, and Supreme Court decided that the days are 16th March to 18th March. So that problem is solved where special leaves are concerned. The first gazette came on the 6th of May 2020. Then I think Supreme Court also found that there are other rules to be amended, and there came another gazette on the 12th of May 2020, that is also in the screen, 2175, where they looked at other rules. They looked at the Rule 21A, Rule 22, Rule 11.3, and 12.2.
I can't see any picture, only the voice.
Okay, we will have the gazettes later. Otherwise, it might take some time to get these things on. Now it's okay. Is it okay now? Can you see, Vijay? Vijay, can you see those gazettes? Maybe you can't hear me. Okay, all right. Then Supreme Court, on the, I said 12th of May 2020, issued another gazette, 2175/2. What they did with that gazette was, I told you that there were some rules that had to be looked at. That is Rule 21A. Now, Rule 2, that's the Appellate Court of Appeal rules of 1988. 1988, you know that in those rules, they made provision for appeals from the High Court to the Court of Appeal. Now, they gave the time limits in, I'll take the first one, Rule 2.1, that is Article 154.5.3. Now, that relates to matters coming under the Constitution, the Magistrates Court appeals, and other appeals from those courts. The courts, the rule said that one has to make the petition of appeal by 14 days. They, by this gazette, I will come to the other one. Then they also looked at Rule 2.2, where the computation of time was given. That was the time that 14 days was rethought of. And then in the same gazette, they looked at Rule 11.3 and Rule 12.2, where when the High Court exercises original jurisdiction, like when they take up these writs of certiorari and habeas corpus, there too time limits were given, notice of appeal within 14 days and decision of appeal within 60 days. Now, Supreme Court, by these two gazettes, looked at it and said, when you are computing these days, leave out that period, that is 16th of March to 18th of March. Now, simply put, if you take the 14-day period, if the supposing the 14-day falls on one of those days between 16th March and 18th March, then you take out all those and we can file that notice of appeal on calculating the balance 14 days from the 18th of March. So the period between this March day 16 to May 18, those were non-working days. Now, to pause and say this, the Supreme Court says that these can be filed, there is no problem, because these are filed in the Supreme Court. Now, we then look at other jurisdictions. The Supreme Court rule, the Supreme Court procedure is governed by these two set of rules, and time limit has been extended. But I found that there is another rule which they had not looked at. That is Rule 25, Court of Appeal rules. Rule 25 says, now you know that there is a procedure where in the Court of Appeal, you can ask for leave to appeal to the Supreme Court from the Court of Appeal itself. If the court grants leave, then it's one. If the court refuses leave, it's something else. When the court refuses, the 42-day period comes from the date of the order. But when the Court of Appeal grants 14 days, it is from from that date. So once again, I think although this Rule 25 is not referred to in the two gazettes, I think this Sena Council will prevail and to act according to how the Supreme Court amended Rule 7 and the other rules about excluding the days, because these cases are coming to the Supreme Court and we can safely say that you can forget about those days. Then, having said that, we come to the next, we'll take out something else. Now, once again, to the Supreme Court, we have the Constitution, Article 126. Now, 126, you are supposed to come within a period of 1 month of the violation. Now, if you come within a period of 1 month, supposing the violation took place on the 12th of March, then what is the date that you have this 1 month period? Now, maybe Sena Council will prevail and we will say 12th of March, then you exclude the day that the Supreme Court has specified, that is from 16th of March to 18th of May, and count the 2 months thereafter, adding on the earlier days. That is, maybe you could do that. But because of the fact that these are, although it is not stated in the rules, these matters will be looked at, and I'm certain that the Supreme Court will also look at it from a different point of view and saying, well, you were not able to come within that period, and Supreme Court officially opened on the 11th, but Supreme Court said that these days are excluded, maybe the Supreme Court will say, okay, we will take the that 1 month period, take into consideration the 63 days that were in the two rules, 7 and rule 2. So that is a thing, and can be 100% sure, I think, that Supreme Court will not dismiss an application where FRs are concerned. If it is, then they will strictly not go on the basis of the interpretation ordinance. Now, why I say the interpretation ordinance is important is that they say that if on the day that one has to say file an appeal, if the office is closed or the registry is closed, you can file on the next date. You can file on the next date. If you take that argument, Supreme Court opened up on the 11th of May. Now, supposing there are applications which would lapse by, say, the 8th, can you file your application on the 11th, the very first working day? Or are we going to think of the 63-day period that is given in the rules and go up to May 18? That's the thing that will be argued, I suppose. So these are problems that not that you will have a lot of problems. These are things that one can imagine can happen. So these are things that can happen. Are we going to say the 1 month period would end on the day that Supreme Court started, but applying the normal law that you file your application on the very first next working day? Or are you going to take that period off if the end date falls within that period? So that's a matter that one day someone will decide that. So we have that problem. Now that's a constitution. Now we have also another issue. If you look at the Civil Procedure Code, you will find certain provisions that are being given. Now, Civil Procedure Code says from the district court, we come to the High Court within 14 days. That's the notice of appeal. Then the petition of appeal is 60 days. Now these rules that I spoke of will not touch these. The Civil Procedure Code is a statute. Now, can someone argue and say, those provisions that I was talking about earlier, about the Rule 7 and the other rule, the provision that have been given could be applicable to the appellate procedure laid down in the Civil Procedure Code? That is another question to be looked at. Now, if we are going to do that, the 14-day period, Civil Procedure Code, because this is nothing to do with special leave. This is something coming to the district, from the district court to the High Court now. One has to look at that position also, whether one is going to look at those days. Now, are we going to say that those days are only applicable to the Supreme Court, or will those days be applicable to other courts and other tribunals as well? Now, DC to the Court of Appeal, 14 days and 60 days. Now, say the judgment was given by the district court on the 10th. Now you have 3 days. Then what is the next date? Now, are we going to exclude those 63 days and then start off again from 18th of March and calculate the balance of the 14-day period? Or are we going to say that we will file it on the next working day? That is a thing again that we have to look. I say that once again because where these district courts and high courts are concerned, especially the high court, some of the high courts started on a certain day. Other high courts started on different dates. The dates of commencement of high courts is not the same. Some started late, some started early. So we have to know the next working day also. So that is another issue. But same thing will apply to the 60-day period. Computation is going to be a little bit of a problem, but I think Sena Council will prevail. And then I don't think the courts will look at it in a, will be looking at it in a more beneficial way. But because of the fact that the Supreme Court has said that period is the day that should be excluded, that's 63 days. So from the statute, now we were talking about the CPC. These days will have to be looked at. Now, once again, a statute. Now, you might ask me why isn't it possible for the Supreme Court to issue a gazette or a rule or anything that effect to change this to coming to in line with what the Supreme Court did for Rule 7 and Rule 2. No, I think it is not possible, otherwise they would have done it, because of the fact that these are statutes involved. The statute gives a time period, and that can only be changed by way of by an amending act. Not even regulations, by an act. Now, to pass an act, there has to be a parliament. We don't have a parliament still. So that this process will go on, we will be talking about it for some more time, till maybe September or whatever the date is, till the parliament is established. Now we have to have a parliament to pass the law. Minister cannot, by way of a gazette or a regulation, change these days, because statute says this is the date, so you have to do it. Now, Chathura was telling me the other day that these regulations that there is a case about the regulations issued by a minister in respect of agrarian services matter, and they changed the date. So that was struck down by the Court of Appeal, and the Court of Appeal said you can't change dates by regulations unless it is specifically stated in the Act itself. You have to go to Parliament and get the Act amended. So we will be having that problem till next March, and I think our President Vijaya, and also we must get together with our President of the Bar Association and meet the minister concerned and see to it that an act is passed as early as possible, rectifying this. Otherwise, there will be problems. And if various interpretations are given by the judges, it can happen with lawyers taking up different views. There will be always three views on this: your view, your opponent's view, and the judge's view. So that there will not be any conformity. So as soon as the Parliament recommences or Parliament comes back, we'll have to get these things amended. That is the thing that we have to do. Now the same problem will arise in this. Now we have this Act 54/2006. Now 54/2006 is the act that gave the power to the High Court to hear appeals. Same thing applies. But of course, there is another thing that you will be discussing in your spare time. Appeal from the High Court to the Supreme Court. Now that is not covered by these rules that I spoke of earlier. Now High Court to the Supreme Court, we know it is 42 days. Now if this problem crops up, now that is not covered by the rules, because the rules say special leave to appeal only. Now we have there is this some time ago, earlier when these High Court started, they try to draw a distinction between a leave to appeal application and a special leave to appeal application. And objections are taken when we file special leave to appeal application to the High Court, from the High Court to the Supreme Court. Then at one point of time, the Supreme Court held that no, you can't have a special leave, you have to have leave to appeal, something that effect. And then those applications were dismissed. Very few. But then immediately there came another judgment which says that there's hardly any difference between a special leave and leave to appeal, and it's 42 days. So we go on that basis that from the High Court to the Supreme Court, though it is leave to appeal, we will say 42 days will apply, and that is how it happens now. That is how it happens now. Then we have this another way to look at this. We have our prescription ordinance. That is for the district court practitioners, I think that will be a headache. Now, prescription ordinance, lays down time limits. Immovable property, 10 years. Written contracts, 6 years. Then verbal contracts, 3 years. Damages, 1 year. That is from that particular date. Now, supposing if that the cause of action arose maybe on the during that period of where the Supreme Court says is pandemic period, or take another example, if it was say on the 10th of March, if it is 10th of March, then if you have to file your, if it is, you have to file your case within 10 years, within 3 years, then that is there. We have to think of situation where the prescription ordinance is concerned, when to file this. If this cause of action was within that period, how do we proceed? If it is on the 1st of April, that's the last date. So last date the courts are closed. Then you can't file this. Now are we going to apply the 63-day period given by the Supreme Court and wait for 18th of May? Or are we going to look at the interpretation ordinance and say we will file this case on the next working day? This is also important. I think the Bar Association and the Colombo Law Society must get together and get some details about when these courts started. I know because of the fact that doing the legal aid commission work, that some courts started early. Some courts started late, very late and early. So we do not know. Say supposing your cause of action, suppose it's in Appellate Procedure. If that court started early, then if this cause of action arose within that period, they might argue and say that you file it in the next working day. Next working day will be the day that the court opens. I know that the courts have been given free hand to open on any day that they want. So that the courts are doing. Civil cases came later, but then there was no uniformity. The criminal cases, of course, they started very much earlier than the civil cases. Of course, the problems will come up. Then you have to think, remember that in your diaries, if you can note down the dates where these, because this, one of us will take it up somewhere. You file it in the next day. The days that is being mentioned by the Supreme Court would not be applicable. The government must declare and say for these acts that these are the days that should be excluded or included. So write down, make note of the dates that some of the courts open. It's different, I know, from Appellate Procedure to Batticaloa side and Ampare side and Ratnapura. Different dates the courts open. So when, supposing if the argument is taken up, this 63-day period is not applicable and it should be the first working day. Be careful of that. Till an act is passed. So till an act is passed, we have to think of that. Then there are certain, I just was going through certain acts at random, and I found that there were some dates given in those acts for appeal purposes. Now the Inland Revenue Act, they say from the appeal from the border review must be 1 month. Now how do you calculate the 1 month? Supposing if this happened, now we are thinking of the Rule 7 and we are thinking of those days 18th and the 16th of March and 18th of May. Now supposing it is from, the order was from on the 14th, then are we going to exclude that period up to 18th of May and then calculate and then file? Remember that those rules don't apply to the to these tribunals. Then supposing if it is on during the order was given and 1 month was during that period, how do you calculate that period? That will also be a question. Of course, these are hypothetical questions, but that might come up with, we know that there are lawyers on both sides. We will argue the case as a brief is given to us. So your client might say, well, this is the way that we argue. Maybe someone will argue and make the law also. So like that. Then we have from the say Land Acquisition Board of Review, they say petition of appeal must be within 21 days. Once again, how do you calculate that? Once again, I go back to what I said earlier. These are statutes, statutory time limits. Statutory time limits, we are still at sea. We do not know how to calculate these dates because there is no act in operation. But at that I will come later how to pass these acts. Then we have this even primary courts appeals there are from criminal within 14 days. How do you calculate that? Because it's not covered by these rules. Then we have LTs. From the LT to the High Court, it's 30 days. Now, LT order given on the 15th of March. How do you calculate these 30 days? That is a matter that you will think. I will not express an opinion because that opinion will be the opinion of one single lawyer. There will be so many lawyers taking a contrary view. But just think about that. Whether we are going to apply the very liberal interpretation given by the Supreme Court to take these days out, that is very beneficial, or whether someone will say, no, you take according to the interpretation ordinance, you take the next date. Or we will say, if that is so, then what is the next date is also a question regarding of course, where the Court of Appeal is concerned, the next day will be the 11th. Because we all started on the 11th, I remember right. Then we have these agricultural tribunal appeals where they say 30 days from the communication of the order. How does one calculate 30 days? Workman's compensation, once again, you have to be very, very careful because if you don't appeal, that poor man will lose his compensation. So something has to be done. I think Colombo Law Society president and the Bar Association president must get together. Colombo, because it's the biggest branch, and to see that something has to be done. But of course, I think we have to look at it in a different way because without an act, how do we do it? I'll come to that later again. Then we have the Rent Act, Rent Board Review. Once again, time limits are given, 21 days. Then we have the CHP, Commissioner's Orders, 1 month. Then we have Admiralty Jurisdiction. Now, Admiralty Jurisdiction is linked to the CPC. Admiralty Jurisdiction, Admiralty Act of 1983, link their appeals to the CPC. So the CPC provisions will apply. So once again, as I said earlier, CPC provisions 14 days, 60 days. How does this time period apply? Whether we are going to go on the basis of the Supreme Court's view of 16th May to 18th or the next working day. Then we have this again on debt recovery. There are certain provisions given, leave to appeals. Then we have the High Court special provision. There are so many acts that have come into that. Now, as I was saying, that how do we get over this difficulty? That's another issue. Practically, I would say, as I said earlier, in your diary, you write it down. Because if you remember that before the 16th of March, I think, there were 2 public holidays. There are certain acts which says you leave out public holidays. So if you leave out public holidays, you calculate the other days. So better now itself, before we forget, in your diary, there I say, what are the public holidays that were given? These are, all of a sudden these days were given. And if I remember right, last Poya Day, the pre-Poya was a public holiday. So when we are computing these dates, that will also be taken into the equation if whether we use the Supreme Court guidelines or any other guideline. Then other matters are, of course, now this is the procedure that is involved. 2 basic questions that will be asked and debated all the time will be this. And to get over this, there was this act that was passed for another purpose. That is the Tsunami Act. You remember the Tsunami Act of 2006? It's 5 of 2006. It is in your screen. Look at section 29. If you look at section 29, you will find that there was the tsunami, and they had also commencement date and an end date, 26 December 2004, ending 26 December 2005, 1 year. Then this act was passed hastily and very quickly also. Of course, there was a parliament at that time. They said in calculating the prescribed time within which any action, appeal or application is required to be instituted or filed, or any act is required to be done in any court or tribunal by any written law, where any act is required to be done within a prescribed time by any written law, the period commencing from December 26, 2004, ending 26 December 2005 shall be excluded. If excluded, that is then according to say, if the person who was required to institute the action to file that action to do the particular act within the prescribed time is a period was affected by tsunami. So we will take it that person who is affected by the pandemic. Now, a similar section will have to be introduced maybe to our prescription ordinance or by a special act, prescription special provisions act, so that we get over these difficulties that we find in prescription ordinance and in the statute. This was one simple section that remedied all the problems that we had during the tsunami days. So we have to have this. Of course, we could have had this. Unfortunately, the minister also could not move parliament because there was no parliament. Then another problem that comes up. Now this act, there will be amendment that will come incorporating this kind of a amendment introducing about the COVID period. Then what happens to those? This will come in somewhere in September. What will happen to those cases? Now we are now back at work. We are full strength now. Now, what will happen to those cases which have been dismissed or which we have not been able to file? Will they come? Supposing if it is dismissed, what will happen to them? If no action is filed, we can take refuge under this. If those cases come up and it has been, say, dismissed summarily because of the fact that it has not been filed within 10 years or 6 years or 3 years, what will happen to those? That's a matter. It's not for the lawyers. It is for the legislature. So these problems will come up in the very near future. Now, having said that, you will also see how we can get over this problem now. Now, it is, I would say, that authorities concerned must meet the legal profession high-ups should meet the minister concerned, and then the pricing of what is going to happen and all these things, and get these acts ready as soon as the parliament recommences. Otherwise, if we wait till parliament comes in, say, September, if we start negotiating, of course we can have, because we have a prime minister is there, we can, of course, we will not know which party will come, that's a different thing. But then have these things in order so that we can get it immediately attended to. Otherwise, again, there will be another delay. And you will also find that sometimes, I'm 100% certain that some clients will take refuge under this. They will tell the lawyer to take this objection. They will say, no, you have to come within this. Why do you want to interpret it in the way that the Supreme Court has interpreted the rules? Why not we get clients like that, why not the next working day? Things like that will be to you and you will have to take a decision. And that is what is important now. to get together and see how we work it out. Of course, I know that in one bar, I will mention the bar also, it's Ratnapura bar, I know. This is told to me by the seniors, that they don't normally take up objection if your list of witnesses are filed late, or if your security is not hypothecated. They don't take that. They don't take that objection. They say, what's the point in taking objection? And in fact, when in one case, when the judge ordered cost to be paid, the other lawyer said, I don't want cost, like that. So that is the conscience of the lawyers there. So in the same way, we should also think of this situation where we were prevented, all of us were prevented because of this COVID thing, and not to take these strict legal objections, but to see that justice be done. So that's one thing that we have to think of. Now, Chathura, he's seated next to me, helping me to. I am not all that computer literate to get these things done. That's why his face is not seen. Oh, you were also saying something about what is appeals, what you had in mind. You can tell me that I can talk about it. Because generally, what I was trying to tell you all is that the procedure is a thing that is rather important, and we know that sometimes we take the objection that when the notice of appeal is filed out of time, we file on the 16th day, they will take the objection, someone did this way. When the petition of appeal is filed out of time, they will, the same thing will come up, because there is no hard and fast rules for statutory appeals. They will say, someone will argue and say, well, in the court of ability here, the working day was this day, although the working day in Ratnapura was something else. So apply that. We were ready, we were doing that, and then they say you take that objection. So that is a thing that we have to look at, and then see how far we can work out things. Because as I said, all contested matters from the primary court ultimately end up in the Supreme Court. There is an appeal procedure from those tribunals to the Court of Appeal, and the Court of Appeal to the Supreme Court, or from those tribunals to now, of course, is maybe to the High Court. From there, it's like that. So this problem of the time bar will become important in time to come. That is because these can be, maybe it is easy to say that if the government or the Prime Minister, Cabinet says that this period is without saying that this should be taken out of the prescription period or something like that, like in the Tsunami Act. Supposing if they issue a gazette to say that this period the government has declared it to be like the Supreme Court pandemic period, so that we know that this period we can use it indirectly, that gazette that is going to be used indirectly for these purposes, and tell if the objection is taken that you are out of time, that the government has declared this period, and therefore you don't have to, for that you don't have an act, you can declare it as like the way that they have been declaring so many things, like they declared some under the Quarantine Act, they declared certain things like that. Supposing there is something to that effect, so that is also be questionable, because you have to declare it under some act. Whether that act gives the power to the cabinet or to the Prime Minister to issue these, but that has to be looked at. But something has to be done that way. So I think that this is the procedure that we normally follow in the Supreme Court. The rules are there. Rules have been amended. That is to exclude a certain period. That is, of course, no problem. Then the acts are there that gives the time period. Those times are still there. They have not been looked at. Whether we are going to apply Supreme Court 63 grace period, or whether we are going to say next working day, is a question that will come up. So these are the things that we will be faced with. And I think I think I have said that I will try and answer any question that you would like to ask.
Yeah. Thank you very much, sir. There is one question that has been posted by one of our viewers that is asked whether since it's a matter of public notice that the courts and the registries did not function from 14th, rather 16th of March to various dates. The Supreme Court reopened on 11th of May and various peripheral courts have opened in between 22nd April to 18th May. So it is not a fact that is disputed by any person. Therefore, when the court registries are closed, can any person argue in a court in case, because still there is no regulation being passed by the Cabinet of Ministers, and there is probably the new parliament might or might not pass a statute. Therefore, in such an instance, the principle applies in generally, that is, law does not expect a person to do impossible things. But does it apply, and when can a party at least take this objection, because impossibilities cannot be expected to be done when the court registry is closed, when the curfew is imposed, when the courts are not functioning? Can a person expected to go and lodge his appeal? So that on that general principle, even without a statute, can't we just avoid calculating or taking into consideration the time of lockdown as a time period that will not apply these rules?
We can always do that. We can take the law into our hands and think that that is the law and file these papers. We have to see how the courts will look at it. That is why I said that in some cases we don't have the first working day, a common working day. It varied from court to court. So that in district court of, say, Tangalla, the first working day would have been, say, the 8th of May. When the same argument that Chathura raised, well, on the 8th day it was open, you can file it. But why should there be a different time period for the Supreme Court and a different time period for other courts? So the Supreme Court says, where the Supreme Court appeals are concerned, 16th May to 18th May is should not be taken into consideration. Whether that is going to apply across the board to all other appeals or not is a question. But it's true that you can't expect someone to do the impossible. Okay, that is the position that will be taken, as I said, by some. Yes, first day you file. Now, my question has always been that, yes, it is good you file. First, find out the day, but also find out why was this 63-day period given by the Supreme Court. Why should it apply only to the Supreme Court when it can apply to other institutions and other appeals also? So just because of public notice, public notice, but what do we see? We see public notice. Some members of the public will agree, some will not. It is not a rule, or it is not the law, or it is the view of some persons. It's not I would say, a thing that can be taken as general. So maybe I always said that is the way that Chathura will argue, but there's someone else who will argue the other way. That is why I say that when there are two arguments, the third person, the judge, will take another view. So that is why we have these problems. We have to have these problems, otherwise lawyers will not accept. Chathura's problem is also correct. He'll say that his position is correct. Why? But then again, other man will argue and say, well, this is the law that is true. We were prevented. The Supreme Court said that these are the dates, so we will exclude those dates and then file our cases. And that should be applicable to all the statutory appeals also. So it's an arguable thing. Good if it is argued that way, because it will be made by a counter argument and some judge will give a decision on that. Maybe we will follow it for some time till some definite order comes from somewhere. It is like this, that there is this problem about whether the police can arrest people during the curfew days and whether the police can seize vehicles. That is a question that was there in the minds of so many people. But apparently, some said you can't, some said you can. But apparently, there is a judgment of the court now. It says you can. So maybe that judgment may not be binding on other courts, but there is a judgment like that. Till he goes to the High Court, and from the High Court to the Supreme Court, that order will be worth looking at. People will be looking at that order. And I know that police are looking at that order and said it's 100% correct. And then it is the law. So it's like that. So you go to court and get an order on that. And it's, I would say, sooner the better. The objection that the way that Chathura argued it, go to court, get an order, and then settle it now itself without waiting till September, till the parliament is convened.
Sir, now, as you said, how can an individual go and file application seeking relief? Is there any specific remedy that you suggest, or rather to take up? Because the thing is, without a matter in dispute, there is no provision for an individual to go before court and ask for clarification.
You file your, say your course of action will expire one of these days, and then you go to court and file and say, I could not file it because of this, although I am out of time. Then the other side will argue in the same way that you argue, or contribute, and then the judge will have to give an order on that. We will take it from there. At least there is a judicial order from some court. There has to be a cause of action by in some court where you test it. You have the test cases, but of course you can't have a test case, you have a good case. Have a test case or a good case and then file and let the other side take the objection and then proceed further. Ultimately end up in the Supreme Court. Maybe we will accelerate it and then get it to the Supreme Court. And the Supreme Court, maybe if it's a matter from the prescription ordinance, I'm 100% certain that Supreme Court will also look at it from the way that they looked at it when they were reframing the issue and said that this period is should be excluded. So let it, it's a good question that he asked because I also missed that. Because you can always test it. Why wait till the next parliament comes? Get your client to file. Because there will be clients who want to file action. Get your file action. Let the other party take the objection and decide.
Now, yeah, in the Tsunami Act, which you referred earlier, there's a specific reference to Section 66 of the Primary Court Procedure Act. Now, sir, rather than prescription, there is a requirement that a disposition, a person who is dispossessed from a property needs to come before court within 2 months.
Yes.
It doesn't say 2 months excluding holidays or excluding time bus. That probably would have been the reason why the specific provision was included in the Tsunami Act to exclude a certain time period with the affected areas from tsunami from Section 66 application. Now, in such an instance, if a person has been dispossessed, say on first week of March. His 2 months period lapses on probably on first week of May.
Yes.
Until first week of May, most of the magistrates' courts did not function. So in such an instance, what would have been, because now it is too late. Of course, it is too late now. So what would have been the remedy that person?
So the thinking behind the tsunami was, I was also instrumental in drafting that, was that the property was destroyed. Tsunami, the property was destroyed. As you say that, supposing if you were dispossessed on the 1st of March and you are supposed to come within 2 months, then so that period fell within that period of 63 days. Well, same question, are you going to apply the rationale of the Supreme Court, or are you going to apply the common law principle of you file your the next date will be the next working date. So that is the thing that I was also repeating, how to apply this, whether you are going to go back to the rationale of the Supreme Court or on the basis of next working day. So that is a matter. The easiest thing is to test in what you propose, test in a 66, because there are so many 66 matters coming up, test it there. And I'm sure the magistrate will give an order, and then we can see how far we can go to Supreme Court. Maybe as a special case, we might be able to, if we appeal and get it accelerated, or something to that effect, and get an order. Because as you say, Parliament may pass or may not pass. That is the thing.
As a summary of your lecture, sir, what I understood or what I grabbed is that it has to be either the Parliament should pass a statute like the Tsunami Act, excluding the period under lockdown or period which has not been able to function, especially the court system, as a period excluding this application of prescription and the rules affecting time. Or else you suggest that even the Cabinet of Ministers, by way of a regulation, can declare that this particular period as a period of non-functioning or something to that effect.
Yeah, to stop at that, I am only saying let them declare. They can't say declare and then say that this period will not be applicable for any matters coming within the prescription ordinance or any ordinance. They cannot do that, because that has to be done by a special act. So they can only declare and say this is this. And then it is for the lawyers to argue it out and say, well, this period there was a lockdown, so it should not be taken into consideration. So that's an opportunity given to a lawyer to proceed further. I think someone will have to do that. At least your president and maybe Kalinga, the president of the Bar Association, must tell the president of the country to at least declare a period so that we will be able to say, well, that period was a pandemic period, no work period. Remember that although we say no work, the people were expected to work from home. So there's another issue involved when you have a period like that. How can you say that it is a pandemic period when all government officers, of course we never got a chance to work because the lawyers, but all government officers were expected to work from home. So that's another problem that we have. So can the government say this is a COVID period? Of course, government can say they are only talking about a period. Although you work from home, and mind you, they got the pay and everything. Although you work from home, this period the government considered as a period of the pandemic. That is for future. When the Parliament passes a law, we can say what was declared as a COVID period should be excluded. So that is another stepping stone for that.
Yeah. And sir, one last question. Now, the 1 month time bar for fundamental right jurisdiction is a constitutional provision. It is not a statute, but the supreme law of the country. So, how would it affect and how would it be amended, or rather it would be relaxed for the time period of lockdown, especially concerning the non-continuing violations? Continuing violation, of course, they can
I would
still.
say that the Supreme Court has decided by issuing that gazette that there is a period of the pandemic, indirectly saying. You also are aware that in some of these fundamental rights applications, though the time bar objection is taken, there are instances where it is explained that we could not lodge this application within the time period. The Supreme Court has used their discretion and their powers under the powers that they have under the Constitution, and disregarded the delay of about 3, 4, 5 days. Of course, those are 3, 4, 5 days, but I'm 100% certain that the Supreme Court is aware that nothing could be done. They will extend that time. Though it is statutory, they have the discretion, because there are cases where the Supreme Court has extended the 1 month period to, it hasn't gone to months, but 10 days to 12 days like that. So the Supreme Court certain will be looking at it from that point of view, because they are the guardians of the people and it's a constitution, and someone violating a right when they are prevented from coming to court due to reasons which they cannot control at all, then the Supreme Court will definitely think of that period and then say, okay, although it is 1 month, we will give you the time.
And sir, there is a question from one of the viewers that what what is the position regarding 4th June, because 4th June was subsequently after relaxing or after opening the courts, it was again been declared as a day of curfew, but I think subsequently the government has declared it as a public holiday. Subsequently.
So,
So
then that will be
not calculated. So that will be a date excluded for any type of calculation.
Calculation that is only a public holiday. And then in some appeals you say that Saturdays, Sundays, and public holidays are excluded. Then some say 42, some 60 days stretch. So there are that day is not included. If it is specifically stated that the public holidays are excluded, then that can be taken out of the equation. So that's why I say that you make a note in your diary the days, because we do not know whether today is a big holiday or a normal holiday. I'm also not certain whether it was declared as a public holiday. You check on that, please, because there was some view. And also, there was another issue where on that nomination day, they said that it was not a public holiday. So check on that. So if it's a public holiday, you exclude. If it's not a public holiday, it's just a holiday, I don't think you can exclude, because statutes will say exclude Saturdays, Sundays, public holidays.
I think, sir, that's about the Q&A session. We have basically answered the questions that has been posted by our viewers. And in wrapping up, what I grab is that we can't, at the time, as a very senior practitioner who's involved in all type of appeals, you are not in a position to give a concrete answer for any of these time bar issues. You can only say that they will be issues that will be tried probably or argued in courts in time to come, unless the parliament enacts a statute covering giving a blanket solution for this issue. So as lawyers, we should keep that in mind, and we should be mindful of either to take that objection if necessary, if our clients advise so, or to face the or defend it in a court of law. So we must find ways and means of facing that type of arguments in court.
I would also add to this, because I'm also involved in these rule matters. Because of that, if the objection, your client says that do take the objection, you have to take the objection. Otherwise, without telling the client, don't do it. Otherwise, they will complain to the Supreme Court saying that this objection was not taken. There's a valid objection, and the Supreme Court might look at it in a different way. Because that has happened.
And so also there's a question now. However, the courts reopened on 11th of May. Yet there was another 1 or 2 weeks time that those several districts, Colombo and Gamage districts, were under curfew. So I think the same answer you will give. There's no difference. This has to be addressed by a statute, regulation, or by a judgment of a court.
Yes.
So what we discussed earlier also, that this will be an eye opener, or this will be an discussion to say which are the areas regarding appellate procedure that could be affected or that could be argued in future times, or the issues that will arise as a result of this pandemic situation. And without the intervention of the parliament or a superior court judgment, no solution can be given by us, including the senior president's council or anybody. As practitioners, we are not in a position to give any solution, rather than giving an opinion.
I will like to say that no lawyer, because there are always two views. I will take this view. Chathura, you might take a different view, because we are entitled to differ, agree to disagree. That's the beauty of the law, the profession. We agree to disagree. My view is this, and there'll be another view. That is why in seminars of this nature, I don't think any person who is a lawyer must. I have said when I talk about disciplinary procedures and rules and ethics, that in these type of lectures that we give, of course, this is to lawyers, so it doesn't matter to the public. Do not come and say that this is the law, that is the law that he is interpreting. If you say that this is the law that I understand, that is enough. because there will always be another opinion, and I would say that there will be the third opinion. But here, of course, this is among us, only lawyers. We can say that I'm taking this view, but still here, I would not say that, because I will leave it to you, because you are also lawyers, leave it to you as he took a different view in one case. I will take a different view, and we are opposed to each other in court, presenting our views all the time. Now, as someone said, we will take the view according to the brief that we get. The brief that we get, we will argue. So it all depends on which side of the coin that you are on. So that's why I said it's not good to give up. You can say that this is the law. You can say, well, this is a way that this can be thought of, but there will be contrary views. So that's what I said, that these are things that can be thrashed out either in court or in some other place, and maybe a time will come when this will be solved. But I suggest that some test case goes up and finishes it before the parliament is the recommendation.
Yeah, thank you very much, sir. I think this marks the end of a very fruitful discussion, rather than a lecture. You have discussed very important points, and it was an eye-opener for the practitioners as well as for the instructing attorneys who are involved in practice in appellate courts as well as original courts. And while thanking on behalf of the Colombo Law Society for your time and the research or the work that you have done amidst of your busy schedule, especially with the Legal Aid Commission work in addition to your court work, I again thank you on behalf of the Colombo Law Society. And to give the closing remarks, I invite our president, Mr. Gamage.
Yeah, before that, I must say, thank you for inviting me. And it's a pleasure to talking to all the lawyers, which I have been doing for the last 40 years. And I must also say that the gazettes that if you are not familiar with, it will be posted, I think, in the Colombo Law Society website. Anyone can access that. And if you have any problem regarding the any case that has that you think of about this time, about the times, whether you can file it on the next working day, you pose a question to your president asking that if there are case law, I will see to it that those cases are given to the president so that he can give it to you. That's another way that, and also it's a great, Mr. President, it's nice to have these, as I was telling Chathura, to have this Friday forums, and it is casual, it's easy, and it's simple, where we talk to each other like talking in the law library. So that's how it should be, without making it a formal affair. We made it simple, we discuss things, and then let's hope that your Friday, I call this a Friday forum, the Friday forum will continue so that more and more people will get interested and involved. Thank you very much.
Thank you, sir. May I now invite our president, Mr. Vijaya Gamage, to give the closing remarks of today's lecture. Thank you,
Chathura. Thank you very much. We have come to the conclusion of today's lecture, rather discussion. But before wrapping up, I would like to thank Rohan Sahabandu, President's Council. As we all are aware, Mr. Sahabandu is always available to help his colleagues, whether senior or junior, with his vast knowledge in law. Especially when it comes to juniors, he is always there to give a helping hand. In a personal note, he has helped me in my professional work as well as work related to Colombo Law Society. I know Mr. Rohan Sahabandu won't take up any invitations for seminars or webinars, but he was kind enough to accept our invitation and to spend time with us. Thank you very much again, sir. Thank you very much for the discussion. I would like to thank the organizers again, Mr. Chathura Galhena, Mr. Sanath Karunaratne, Mr. Nalin, Samarakoon, and Mr. Imaz, Imthiyaz. Thank you very much for organizing this. As Mr. Rohan Sahabandu, the President's Council, said, we would be posting all the relevant documents in our website, and the other documents as well will make available to you. Then we'll be organizing this e-lecture series next Friday evening as well. So I invite you all to join with us next Friday as well. Thank you.